Imagine being trusted with an M4 rifle in the United States military. Imagine being sent overseas carrying a firearm in defense of your country. Imagine being expected to risk your life or even die if necessary, but then coming home and being told you're too young or not mature enough to legally buy a firearm for yourself. This isn't a hypothetical. That's the contradiction at the center of a Second Amendment case now headed towards the United States Supreme Court. And depending on what the justices decide, it could answer a question that has divided courts across America for years. Do legal adults between the ages of 18 and 20 actually possess the full protection of the Second Amendment? Because right now in Florida, a 20-year-old, he can vote for president. They can sign a contract. They can get married. They can join the military and carry a rifle in defense of their country. But they cannot legally walk into a gun store and purchase a firearm from a licensed dealer. Now, the National Rifle Association is asking the Supreme Court to decide whether that contradiction can stand under the Constitution. And that answer could reshape gun rights nationwide. The case revolves around a Florida law that was passed in 2018 following the shooting at Stoneman Douglas High School. The law imposed a blanket prohibition on firearms purchased by anyone under the age of 21 from federally licensed firearm dealers. Not handguns, not certain firearms, all firearms. Under the law, an 18-year-old adult cannot legally purchase a rifle, shotgun, or handgun from a licensed dealer. And violating the law isn't just a minor offense. The penalties can include up to 5 years in prison, a $5,000 fine, or both. And this isn't a waiting period. It isn't a background check requirement. It is an outright ban on purchases by an entire category of legal adults. A lot of people hear about this case and assume it's simply another gun control debate. But the implications reach much further. Because if government can declare someone an adult for every major responsibility in life, but not for a constitutional right, where does that principle stop? They're even being taxed by the government. And one of the craziest things is they can be tried as an adult and be held fully accountable under the law. So society gives them adult responsibilities, but the government demands adult accountability. But in some states, those same adults are denied access to constitutional rights that older adults simply enjoy. For many Americans, that's the serious constitutional inconsistency here. The NRA challenged the law in federal court, arguing that the restrictions violates the Second Amendment's rights of adults aged 18 through 20. And after years of litigation, the case eventually reached the 11th Circuit Court of Appeals. In March 2025, the full 11th Circuit upheld Florida's law. But what's important is the court's decision was deeply divided. Multiple judges reached different conclusions about why the law should survive constitutional review. When courts are fractured like this, it often signals that the legal issue remains unsettled. And when major federal courts disagree on fundamental constitutional questions, that's exactly the type of dispute the Supreme Court often steps in to resolve. This is why the NRA now has filed the petition asking the justices to hear the case. A major part of this case revolves around the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen. Bruen changed how courts evaluate gun laws. Before Bruen, courts often balanced government interest against constitutional rights. After Bruen, courts must instead examine history. The question becomes, is the challenged law consistent with America's historical tradition of firearm regulations? If a similar restriction did not exist during the nation's founding era, courts are supposed to be skeptical of modern regulations. The NRA argues that history actually cuts against Florida's laws. In early America, young adults were expected to possess firearms. Many militia laws required them to appear with guns. Young men were considered part of the nation's defense structure. The NRA argues that if America's founders expected young adults to possess firearms, then modern government cannot simply remove those rights today. My personal opinion, I think that this case highlights a contradiction that lawmakers have avoided addressing for years. You're either an adult or you're not. Government doesn't get to have it both ways. If an 18-year-old adult is mature enough to vote for for the people who run the country, serve in the military, sign legal contracts, pay taxes, sit on a jury, and face adult criminal penalties, then that person should be treated as an adult when constitutional rights are involved. The Constitution doesn't create a category called almost adults. The Second Amendment doesn't say the people except adults under 21. It says the people. And if constitutional rights can be delayed until age 21, then the obvious question becomes, why stop there? Could lawmakers someday argue that other constitutional rights should be restricted under 21? The principle matters because constitutional rights aren't supposed to depend on whether politicians believe you're old enough to exercise them. They either exist or they don't. And in my view, when someone reaches legal adulthood, those rights should apply equally. One reason this case has a real chance of attracting Supreme Court attention is because federal courts are increasingly divided. Some appellate courts have ruled that adults under 21 are protected by the Second Amendment and that broad restrictions are unconstitutional. Others have upheld similar laws. That means constitutional protection currently vary depending where someone lives, and that is a problem. The Constitution should not mean one thing in Florida and another somewhere else. If the court agrees to hear the case, the ruling could answer several major questions. Do adults aged 18 to 20 possess full Second Amendment protections? Can states impose blanket firearm purchase bans on legal adults? How far does the Bruen framework extend? What historical evidence is sufficient to justify modern firearm regulations? The answer could influence gun laws across the entire country. If the court strikes down Florida's law, states across the country could face challenges to similar age-based restrictions. If the court upholds the law, states may receive broader authority to regulate firearm purchases based on age. Or the court could issue a narrow ruling that focuses specifically on Florida's state while leaving broader questions unresolved. At its core, the case asks a simple question. When does adulthood actually begin? At 18, Americans are trusted with some of the most serious responsibilities imaginable. So should constitutional rights begin at adulthood too? Or can government continue treating some adults as second-class citizens when it comes to fundamental rights? The Supreme Court may soon have the answer. And if it does, the ruling could reshape Second Amendment law for an entire generation of Americans. For now, Florida's law remains in place. But the fight over the rights belong to young adults has officially reached the doorstep of the Supreme Court, and that decision could change everything.